In this video, we turn to the next primary source of international law, customary international law. So what is customary international law? It is a binding primary source of international law that is mostly unwritten, but it can and has been codified in treaties. By default, customary international law binds all states, even newly formed states. The only time a state will not be bound by customary international law is if they are a persistent objector thereto. Customary international law is made up of two elements. They are usus, which is general practice, and opinio juris, which is the acceptance of the rule as law. To determine the general practice of states for the purposes of customary international law, we look at three things: the state's actual physical practice, their verbal acts, and their deliberate inactions. To find evidence of general practice, we can look to a few places, including diplomatic acts and correspondence, executive conduct like the actions of presidents, operational conduct like military manuals, and national legislation. Importantly, this is not a closed list. Importantly, the practice must be general, and for the purposes of customary international law, general has a very specific meaning and a very high threshold. To meet the threshold, the practice must be sufficiently widespread, representative, and virtually uniform. Virtually uniform means that more than just a few states must engage in the practice, and that the practice should basically be found in any state in the world. The second element necessary for a rule to be considered a rule of customary international law is the fact that the rule must be accepted as law. Opinio juris requires a psychological element. States must believe that it is a rule that has become law, even though it might not be written down. They must abide by customary international law rules because they believe that they are legally obliged to do so, not out of habit or the desire to be popular. In order to find evidence that a state believes a certain rule has gained customary status, we can look to public statements on behalf of states, official publications, government legal opinions, diplomatic correspondence, and the decisions of national courts. Jus Cogens norms provide some examples of customary international law. Such norms include the prohibition against slavery, apartheid, torture, war crimes, crimes against humanity, genocide, and piracy. This brings us to the end of your video on customary international law. Your next video will discuss how to approach and answer international law questions. Thank you for your attention.